Trotter, you're still under your previous oath. Counsel.
Thank you, Justice. Ms. Trotter, may you please turn to ELAH 56, ELA 56.
Thank you.
I just want to refer you to this page. Just bear with me for a second. Please turn to page 6, the one which is marked with a marker. At the top, right? Do you see that?
I don't know if it's marked with a marker.
Yes, like on the right, yes.
Yeah.
Page 6.
Yeah.
Yes. Towards...
It's page 4 of your report.
Thank you.
Yes. The second paragraph, where it is recorded that the team conducted consultations with 11 families of deceased individuals. Do you see that?
Mm-hmm. Yes.
And further, it is stated that those consulted include, then it makes reference to those families. And on counting, like it appears that indeed it is 11 families.
Yes.
From your testimony that you were able to establish that there was there were no signs of trauma in respect of one of the families. Can you assist us and give us an indication which of those families did not demonstrate signs of trauma?
Certainly. The Reverend Joseph Maboe, he was interviewed alone, and he did not demonstrate any signs or symptoms of trauma. He was in pain, but he wasn't showing signs of trauma.
And you did say so somewhere in the body of the report, I remember. I just can't immediately find it. You may proceed, Counsel.
Thank you, Justice. Ms. Trotter, on Friday you dealt extensively with the definition of torture, like from your interaction, or from your involvement in the preparation of the report. Yes, I have managed to get the definition of torture under the United Nations Torture Convention of 1984. Are you familiar with it?
No, I'm not.
Okay. It is defined as follows. Torture involves intentional affliction of pain by a public official to obtain information. Then the definition goes further to say the full definition of torture in the convention is any act by which severe pain or suffering, whether physical or mental, is intentionally inflicted on a person for such purposes as obtaining from him or a third person information or a confession, punishing him for an act he or a third person has committed or is suspected of having committed, or intimidating or coercing him or a third person, or for any reason based on discrimination of any kind, when such pain or suffering is inflicted by or at the instigation of or with the consent or acquiescence of a public official or other person acting in an official capacity. And then lastly, it says that this definition excludes pain or suffering arising only from inherent in or incidental to lawful sanctions, which seems designed to permit the death penalty. From of that definition.
No, but are you saying to the witness the only object of torture is obtaining information? I think you should formulate it clearer. There are several objects of torture, and that is one of them you're putting to her. But I think you should make it quite clear that you're putting the one objective to her.
Thank you,
So
Justice.
we don't have, I'm just saying that the question should be clear, that's all I'm saying. Okay.
From my reading of the definition of torture in the convention, it makes reference that the object will be to obtain information from the person subjected to such trauma, to such torture. So what I'm asking from you is that from your assessment of the information, would that fall within that definition as set out in the convention?
No, it doesn't. I have a different definition of torture.
Okay.
But just for clarity's sake, counsel, the definition you've just read, I don't have it before me. It has three parts to it, does it?
Yes.
What are the other objects besides extracting information?
Well, the object is for purposes of obtaining information by various means by various means of conduct. It be by coercing, by torturing, intimidation. It lists the manner in which such information, coercion, and so forth. But like the main objective, according to the definition, is only
Just read it again.
The full definition of torture in the convention is any act by which severe pain or suffering, whether physical or mental, is intentionally inflicted on a person for such purposes as obtaining from him or a third person information or confession, punishing him for an act he or the third person has committed or is suspected of having committed, or intimidating or coercing him or a third person, or for any reason based on discrimination of any kind, when such pain or suffering is inflicted by or at the instigation of or with the consent or acquiescence of a public official.
So you could torture to get information, you could torture to punish, you could torture out of hatred and discrimination, isn't it?
Yes, with the object of obtaining information.
No, Council, you just read it now. We all are listening, isn't it? I haven't got it before me. Do you have a copy?
I'll make a copy
You
available.
torture to extract information, you torture to punish, you torture out of hatred or exclusion, you torture, isn't it? Extracting information, as I understand you read it, is a subset of a number of purposes of torturing. Or am I totally lost?
Well, that's what it provides.
So there's one purpose, there are several purposes why you could torture somebody.
That's what appears like from the definition.
I see,
Yeah.
okay. Thank you.
Thank you.
I always try to understand the reason for a question, because questions always put, at least in law, they're put for a reason, to establish a proposition or to counter evidence put up by another. Is it the state's attitude that this did not approximate torture? Is that where we're going?
Indeed, so, Justice.
Yeah. I think it should be put to the witness in all fairness so she can respond to it and say, I think it is, so that we understand the difference.
Thank you, Justice.
Thank you.
Ms. Trotter, from the definition which I have read from the convention, I put it to you that it is quite clear that what had actually happened was a tragedy which unfolded. There was no intention at all on the part of the government to punish those who were affected. So in short, what I say to you is that there was never any intention to punish or to cause pain to those who have been affected. What's your response?
I don't agree with that.
Okay. In your you stated that if a home is disrupted, it comes with the most severe social stresses. Do you recall that?
I'm actually quoting the Diagnostic and Statistical Manual of Mental Health Disorders. I'm making the point that in that document, that is their opinion, that this is such a severe social stressor that they would argue that it's the most stressful one. I mean, I agree with it, but I'm basically giving you a reference for it.
And then on that aspect, like you were making reference to the mental health care users, not so? The effect of the disruption of the home, was it in respect of the mental health care users, or was it in respect of the family members?
The argument has two parts. Well, if you're going to put it that way, three parts. So the first premise is that for all of us, for everyone, not just for the families, not just for patients, some experience of a home.
Any further?
Okay.
And
For me, as the adjudicator, it is always helpful to know what are the things that the other party is contesting and which aren't they contesting. That's the only thing I'm trying to establish, obviously. I want to understand which part does the state reject, either the opinion, and which part does the state not contest. You're not obliged to do that, but if you ask questions, an adjudicator will tell you, ask, are they arguing this or are they contesting this? And that's why in our tradition, in our law, you put a proposition to the witness in the end. If you don't agree, you say, I don't agree. That's what a put is about. I've heard you, but I don't think you have sufficient evidence to make the conclusion. Or I've heard you, I think you're wrong. I heard you, I think I'm not contesting. That always helps at any rate. For the adjudicator to know exactly where the points of difference are. But anyway, you may proceed.
Thank you, Justice. That will be the end of the questions.
Okay. Thank you. And that gets us back to re-examination. Advocate Hassan.
Just you need to switch off one of your mics, please.
Oh. Well, I've switched off both. I hope that will give you double the voice.
I need it. Good afternoon, Ms. Trotter.
Good afternoon.
Thank you for making yourself available again for this hearing. I only have a couple of questions in re-examination. And perhaps I'll begin with where my learned friend left off. And that is with the findings of the Reverend not showing signs of trauma. Is it your opinion that someone who does not show signs of trauma is not experiencing trauma or is not likely to experience trauma? Can you help us to understand why there would be that manifestation of feelings in a person? And what it means? What are we to make of that?
Look, it's highly likely that someone is traumatized and they have a delayed response. So the fact that someone is not traumatized immediately afterwards is not uncommon, because one of the three dominant features of trauma is that you try to avoid any cue or any association with the trauma. So often people after the trauma will shut down, they'll go numb, and the trauma can take a long time to manifest. Often what happens is there will be another loss or another crisis, and then that will be the straw that breaks the camel's back, and the person will then show signs of trauma. In the Reverend Maboe's case, he'd lost his wife. He has a very, very deep and profound faith in God, and because of that faith, he is able in his mind to mitigate against the trauma.
He lost his son.
He lost his son, but before that he'd lost his wife. And so what he spoke about was that having lost his wife, which was devastating for him, in some way, and his age, this is not a young...
For my benefit, would you tell me of the balance?
So the one sign of trauma is what we would call increased arousal. So that the whole sort of neurobiological and psychological system is aroused in a way that we wouldn't expect if someone had not been traumatized. And that can manifest at a physiological level, at an emotional, at a psychological level. So for the classic one is startle response, where if you haven't been traumatized, you might hear a sharp, loud sound and not respond. If you've been traumatized, it's highly likely that even a door closing is going to give you a fright, because your physiology is in that sort of exaggerated state of arousal. The second main feature is an attempt to avoid all cues and associations with the trauma, both internal and both external. So anything on the outside world, the person would try and not expose themselves to. But at the same time, what makes it really hard is you might choose not to go back to Takalani and traumatize yourself in that way, but you can't stop internal cues. So internal cues will be coming up the whole time that you will then desperately try and avoid. So you might deny your feelings so that you are not reminded of the trauma. And the third thing is, it's a feature that's about, I mean, if you remember the definition of trauma, it's that an experience that you weren't ready for, that is horrifying, slipped in because you were unprepared and there was no witness to it internally. So what that means is, because you didn't witness it in the moment and find words to describe it and say, okay, well, it's like this in my life. So
it has to be a horrific experience.
exactly, life-threatening. So that's why we can say everyone we can anticipate more or less anyone would respond in a similar way, precisely because the event threatens psychological integrity and it's outside of ordinary normal experience. So what happens is the imprint is there, but it hasn't been processed and digested. So the third feature is that, which is probably the hardest feature of all, and in these families it is so florid, is that then the imprint of the trauma keeps returning in unbidden ways. So you have a flashback, or you can't stop dreaming about the person. So Sophie Mangena talks about how she dreams about her mother, and her mother was this extraordinary mother, and she was fierce and she was available. Then she got vascular dementia, and the last time that she saw her mother had this sort of dead, medicated look. She went with her sister and her brother to see her. And now when she dreams, she can't dream about her mother smiling, and she can't dream about her mother being fierce.
And she was here. She told us that herself.
And that dream tortures her. I think it was her sister, Boitumelo.
Boitumelo, right? Yeah.
And Sophie's the one, her sister, who has the dream. So those kinds of flashbacks, dreams, intrusive memories, that's probably the hardest part of trauma, because you can't stop it. And so you start being traumatized in a way, not just by the event that you weren't able to metabolize, but by your own experience of yourself. And that's what's so hard about continuous trauma. If the event is over and it's sealed, you can then begin to say, okay, what impact has this had on me? How has it changed me? How do I mourn that I've lost that version of myself? When you're in a situation like this and you're fighting for justice, for truth, trying to make sense of everything, you can't seal it off. And so then there's a greater possibility of all the flashbacks, etc., etc. So Christine, for example, says that if she thought about Virginia calling out, she would never ever want to wake up again in the world. It's that kind of internal persecution.
Thank you.
Ms. Trotter, in your evidence in chief, we traversed some of your findings, particularly the language you used of degradation and dehumanization. Can you explain to us, you have already explained your history and your experience. My understanding, I just want to ensure that we all are on the same page, is that these are exceptional, what you have found and what the team has found is exceptional.
Correct.
And would you say then that the treatment was inhumane?
I would definitely say that. And without a cause. So if we go back to the states of emergency, the apartheid era, partly what mitigated, again, not that people weren't traumatized, but partly what helped people deal with their experiences was a cause. And when you have a cause and you believe that cause is just and you're fighting for it, it helps you internally manage traumatic experiences. I think one of the devastating things about this situation is no one can find a cause. And so then it's like we've all been thrown into space because we can't hold on, we can't make meaning of it, we can't understand it. without a cause. So I think that's why the picture's so catastrophic.
But was this an intentional plan to cause harm? I think counsel sought to tax you on that.
Yeah.
To say, well, how can you say this is torture? This was not an intentional plan to cause harm. Negligent, maybe. Uncaring, maybe. Careless, maybe. But was this an intentional plan to cause harm?
There's no way that I can say that it was.
Can you say that it was not?
I can't say that it was not, and I can say that one of the that apart from negligence, not taking care, the lack of ethics, all the things that we've discussed a lot. From my point of view as a psychologist, one of the biggest problems in this situation is the erasure of reality. So you do something because inside you, that's the way you wish it to be, and that's what you want to do, which is what seems to have happened with this relocation. And then you erase the reality on the outside of you, and partially what's been erased is all the knowledge, expertise, information around moving psychiatric patients. But in a way, the same thing has happened with the State's Council today. There's an attempt to erase knowledge, information, expertise about trauma that is derived from many different places. So we get very stuck if we just trust what's inside us and then refuse to acknowledge that outside of this is reality. And in that reality are things we don't like, information, etc.
I understand the erasure point, and I'm not there. What I'm trying to settle in my own mind is, was this an act of torture? I am going to hatefully kill them, or I am going to expose them to horrendous treatment so that they die or suffer. Or was it a case of neglect? A case of unethical conduct? A case of low levels of caring? A case of recklessness and negligence? I'm trying to locate it. It was, you were text on that, and counsel sought to debate that with you, with all those quotations about what torture is. What is your response?
So in terms of the Gauteng Department of Health, I can't say that it's any more than unethical, negligent, ignoring all the information that's available. In terms of the people...
The Ombudsman says reckless, he adds those things.
Exactly, and deviation from principles.
Deviation from principle, deviation from the law.
Yeah, and I agree with that. Once we move into the NGO environments, we now have a different argument, because now we have got people watching someone dehydrate. For example, the Reverend Maboe tells us he was told that Billy could not have water because, to quote, he would pee in his pants. So at this point, that's not just negligence. This now, or you lock someone in a filing room without food and forget that. I mean, we all know all the different examples. So if you watch someone starving and dehydrating to death, for me, that is torture. Then on top of it, from the Ombuds report and from all the testimony I've heard here in the arbitration, as well as what came out of the interviews, people were physically injured. That's torture.
Counsel.
Thank you, Justice. I was going to go down a similar line of questions, but your responses to the Justice take care of that. My final question, then, is whether at any time you were placed under undue pressure, undue influence to come to the findings in your report.
Absolutely not in any way. I mean, what I'm absolutely clear about is none of you could have developed this protocol, argued it theoretically, done the interviews, and written the report that I wrote. In fact, well, no, let me not go there. There's absolutely no way that I was under pressure. And anyone who knows me would know that I'm not that kind of person. That the one thing I value is the independence of my own mind, especially in a situation like this, which is so important for our country and for our children. If I may say, my son on Saturday, so he came up to me and said, "Mom, you're looking distressed again. Is it about Odie, who's our dog that died 10 days ago, or is it about the arbitration?" And I said to him, "It's about the arbitration." And he said to me, "Mom, I really don't like this arbitration. It's interfering with your mothering." And I said to him, "I know, but this is so important for your future. And so you're just going to have to manage it until it's over. That's why I've done this."
You could have said all of the above.
Exactly.
Funnily enough, my son asked me the same question over the weekend and asked whether I can quit. Can I quit this job now? And I said, "No, I can't." And just to emphasize the point on the independent, you sought to have, is it normal to have independent peer review when you undertake studies and research?
No, that's not ordinary. That came very much out of these circumstances where you've got this sort of series of events where all kinds of things are dropped and forgotten. ID documents, people, autopsy results, bodies. So for me, that as a clinician would have been a red light, because what happens in life is if something like that has happened in the Marathon Project, and now I'm going to investigate that, something called parallel process, which means often the process repeats itself in the investigation or in the arbitration. So I would know that about anything. In this particular situation, as I explained before, Ms. Rajeje's email disappeared into virtual reality. And when I then got the email again and realized what it was about, I felt absolutely devastated that this, I'm sure you would have got someone else, but that this arbitration might have proceeded without testimony from clinicians. So from that point onwards, you can ask the team. I kept saying, the big risk here is for us to drop balls. You're going to interview in pairs. We're going to get people checking all the time so that we don't drop a ball. So that's where that came from.
Thank you. I would like to, for the record, thank you and your team for your selfless service to the arbitration.
You're
Thanks.
welcome.
There are no further questions from me, Justice Musselwhite.
Thank you. There was an insinuation, though, that by attaching the Hillsborough report, the Hillsborough disaster report, you were acting less than as independently as you are required to as an expert. I wonder what your response is to that. Simply, why did you attach the report to your expert opinion?
Look, I don't know of another report that in some way is so similar, not just because of the tragedy itself, but because for the Hillsborough families, it took such a long period of time to get justice. And that felt for me like two features of this are reflected in that report. Honestly, I think the report it's a good report, but it wasn't that impressive for me. There were three things that the Reverend Jones said that I thought, oh, that applies exactly here. And that's a beautiful quote, because sometimes when we use other people's words, they say something in a more meaningful way. Also, the Hillsborough report, my report was written And the Hillsborough report in no way at all, substantially in terms of content, and I can alert you to the 3 quotes from the Hillsborough report, but it in absolutely no way changed my report. It was all done and dusted. I had always felt that the ending to my report was a bit sort of unimpressive. And then when I read the Hillsborough report, his last 3 lines, which I read on Friday, about something like this having a vicarious quality and a meaning for all South Africans, I love that. And that's why I ended my report that way. And the other thing I loved was what he said about a false public narrative is an injustice in itself. And I thought, well, that's so true in terms of what we're trying to do here. But it substantially changed nothing.
And it's not a clinical report in the sense of yours.
Exactly.
That's what struck me, that it sought to sweep across many areas. Policing, the inquest, the response of victims, the response of communities and of the nation, and so on. So it's a report that is much more sweeping than one that is clinical in its narrow focus.
That's exactly right. And in fact, when I read it, I felt very pleased with my report because I thought, actually, the Reverend Jones could not have linked the things I'd linked. All he could do was quote the families, really, and then arrive at some ethical learning points.
But in fact, if one ignored it, no harm would come to your report.
Could be completely
because Reverend
ignored.
Jones is not a clinician,
Yeah,
not by any means.
Exactly.
He's a public thinker, but not a clinician as yourselves. Okay. And the last thing I thought I would raise, which always entitles you to re-examine if anything comes up, which really is Counsel for the State somewhat obliquely insinuated that you were called to make the compensation end of this inquiry more stacked against the state.
No, that's not what the email said. The email to me said that what would be helpful would be to have clinical information, so a view of the families that wasn't them giving testimony and listening to their narratives, but a view of the families that was based on our clinical knowledge and expertise.
Listen again to my question. The question really is, there's an insinuation that you have placed a thumb on the one scale so that compensation may be higher than otherwise.
Not at all. All I was told was that it may help inform you about the nature of the compensation. And for me, it was always very clear that that outcome applied to things like memorial services. You know, the compensation is part of it. There was no pressure. I mean, I'm not even sure exactly what that means. So there was no pressure in terms of an amount at all. And the families made it clear that what matters to them as much, and for some families more, is restoring dignity, truth, etc. So for me, that as a psychologist became the focus. It's for you to use the report in terms of assessing compensation amounts.
Again, albeit obliquely, was that you here to make out an argument in favor of the claimants.
So if
and that's how you saw the task at hand. What's your response to that?
If the issue of compensation disappeared, I would have written exactly the same report.
Very well. Is there any re-examination that arises from the questions I've asked? For that matter, would any counsel like to ask any more questions?
We have no questions. Thank you, Justice.
We have no questions.
Counsel,
Will not proceed to have
You-
any questions.
you have no questions. You're procedurally entitled to follow up if a court raises new matter that you might want to clear up, but there are no questions as I understand. Well, we've come to the end of the road. It's a bit of a taste of what lawyers do to psychoanalysts.
I'll be writing a paper about it.
Very well, but again, thank you for coming out and thank you
Welcome.
being part of this process to try and get at the truth in all its complex manifestations.
You're most welcome.
Sure, thank you. You are indeed excused. And again, thank you for working pro bono in a world where money seems to be everything.
You're most welcome.
Yeah, thank you.
Justice Masaneke, we're ready to call our next witness,
Yes, indeed.
Dr. Talatala.
Let's go on. I beg your pardon, Counsel?
May I just be given one opportunity?
Yes, certainly.
We have noted the sequence of the witnesses who are going to be called, the expert witnesses to be called by Section 27. And amongst them is Dr. Talatala and Dr. Chemba. We have expressed our reservation for their appearance as expert witnesses on behalf of Section 27. And this issue, I've raised it last week. But however, they are charged to proceed with those witnesses. And our concerns emanate from the fact that the two doctors deposed to founding affidavits in the agent application on the instructions of Section 27. Dr. Chemba deposed to a founding affidavit of that application, which appears at page 97 of file 1. And then Dr. Talatala deposed to a confirmatory affidavit in support of the application at page 338 of file 1.
File 1. Yes. And what is the legal objection to their testifying? What is the legal premise for the object? Yeah.
We submit that they cannot appear before these proceedings as the hired guns on behalf of Section 27 because their independence is questioned by virtue of their association with the claimants in these proceedings. And with regard to the two cases which I had previously referred to, the PricewaterhouseCoopers, the court has given guidelines when will credibility of a witness be called to question. So I just want to inquire from you, Justice, whether will this be an opportune moment for us to formally raise our objection and set out exactly what it is expected of an expert witness in the proceedings?
put your exact finger on it. You're saying that is qualified because they had in the past deposed to affidavits in support of a case of the claimants.
Indeed so.
You must, counsel, have had cases of two engineers, accountants, or other experts called on the one end by the claimant and on the other end by the respondent. You've no doubt come across such cases, haven't you? The one claimant would call one or two surgeons on the one end, and the defendant will call two surgeons, all dubbed experts. And in the end, the court is called upon to make a preference, to make a finding of preference on expert testimony, isn't it?
Well,
So experts are not freewheeling people all the time. They may have a view that, and another expert may have an opposite view, and you're entitled, aren't you, to call experts that support your proposition and others that counter it. And courts every day have to make the decision about which expert testimony is preferable?
well, Justice, our concern is not on the expertise of the witnesses. Our concern arises from the fact that they are partisan to the claimants in the matter. They were parties. They were not called as witnesses. They were instituting proceedings on behalf of the claimants.
Sure. I take the point. And that would be a valid argument to raise when you evaluate the evidence, it might be, isn't it? I'm just trying, counsel, to draw a line between should a witness be prevented from testifying on the one hand, and what weight I as arbitrator ought to put on the evidence. You get the difference?
Yes. Well, our main concern is that these are matters that we need to set them out forthright.
Sure. No, the point is validly made and at the right time. I don't think you're making it at the right time, but you're not asking that the witness be prevented because, in your view, it's an expert that has already made up his mind about the issues. Then that's a criticism that you validly raise and say, don't place much weight on Dr. Talatala's evidence because he has picked a side much earlier. And that's a fair criticism. Two motor collision reconstruction experts on two sides, two auditors on two sides. It happens all the time. And the state might want to call experts after the expert testimony here in an attempt to refute the opinions raised by the other expert. But the right time to raise it is now. And I'll hear what your colleagues say, to say, we don't think this expert is independent. He has shown his hand before. And let your colleagues respond to that, and that will be on the record to show that you've raised the matter and you have concerns about the non-partisanship as distinct from the expertise of the witness. Any more points you'd like to make before I turn to your colleagues?
No further submissions.
So, thank you. Counsel. Is the witness disqualified?
No, Justice Masaneke, thank you. In fact, it's quite ironic that it's the question of independence that's being raised as a grounds for disqualification in respect of this witness. Because the reason this witness was called is because he exercised independence at the time that the Marathon Project was ongoing. He exercised his independence by raising his concerns, by taking steps. And to that extent, that is true, that he did take steps in the course of the facts that are before this tribunal. He did so because he was acting, and I will leave it for him to speak if he's allowed to provide testimony, out of an ethical duty as a psychiatrist. And it's for that reason that we've called Dr. Talatala, because in fact, the question of independence of the medical professionals who were involved, now let's leave aside the government officials, but those who are medically qualified and what obligations rested on them, firstly. Secondly, my learned friend says that Dr. Talatala filed affidavit in the December 2015 litigation on the instructions of Section 27. Well, he's got the cat by the tail. It was Section 27 who filed that affidavit on the instructions of Dr. Talatala. They were acting as legal representatives. He instructed them to file the affidavit in support of a motion to draw a halt, to hold for a brief period of time while things get sorted out. It was an interim meeting.
It makes Advocate Hutama's point even more so. He's saying, rightly or wrongly, he picked sides.
We're not calling, let me also clarify this, that he is here in order to provide testimony, direct testimony, of his involvement in this project over the last two years.
So you don't seek to qualify him as
only to this extent.
As a psychiatrist, yeah.
No, I do. And he sets it out in his affidavit that's before the tribunal, his report that's before the tribunal, that he is a psychiatrist. And the reason that's relevant is because his actions were determined as a result of his qualification. And so he's here to testify as to what he saw, what he did, and why he did it.
Yeah, but a pick has to be made. You see, the argument is that law of evidence privileges expert witnesses. It allows them to flourish, to draw inferences from facts that are already steady, established. That's really what the regime is. You're allowed as an expert to, but if you come in to depose the facts yourself, then you subjected the normal rules of tendering evidence. So that is why at the beginning we have to make a pick, whether a witness is allowed the flourish of opinion or the witness is constrained by what the witness knows, has seen sensorially and cognitively.
If it assists the tribunal, then we don't need to refer to this witness as an expert witness in the narrow sense understood in litigation.
Yes.
His expertise, however, is relevant to his direct testimony.
Yes.
And whatever his testimony is in that regard and whatever opinions may emerge is for the arbitrator to decide what weight to place on it. And if it assists the tribunal to not refer to him as an expert witness, we are calling him as a direct witness. We are comfortable with that.
Yeah, very well. Is there anything you'd like to say, Advocate Krause, on this debate?
Thank you, Justice Museneke. I'm a little bit taken aback by the objection. I have never heard that a person objects to the witness being called. That is questions that you put to a witness, whether he is in fact independent. And it's ultimately for the court to decide. And it might be, and as you know, we've come late into the whole arbitration. And it might be that we want to ask the witness some questions that might be seeking an opinion, and he is qualified. So from our side, it's for the arbitration, as per our previous argument, it's for the arbitrator to decide at the end what value to place and on what facts those things, the opinions were based. But to object beforehand, it seems to me like a game being played, with due respect to my learned friend, of trying to unsettle the witness or unsettle
No, but they are surely the minimum entitled to say, you litigated against us in the past. You can't now come and say, I'm an expert witness who can provide opinion untarnished by bias.
With respect, Justice Musaneke, that is a question for the arbitrator to decide after hearing the evidence, not before hearing the evidence. And it's not for a party to object to the calling of another party's witnesses. That will directly infringe on your right to the access to court. And I can't think that that can ever be allowed.
But why wouldn't a party say, I don't think he is an expert witness in this matter, for reason that he or she has already taken sides, already has a known opinion.
But for every witness that is so, Justice Musaneke, every witness that comes have already taken a side in this matter. Why would this witness be different? With respect, I cannot see that before witnesses testified that the court can decide whether he is so biased that his testimony can't be relied on.
The party that calls the witness has to make up her mind whether the witness is called qua direct evidence witness or a specialist or expert witness. So that choice needs to be made clear to the court. And the court knows what leeway to allow the witness. So when they object to hearsay, or they object to any of all those traditional objections, rulings will be different depending on whether the witness is an expert or a freewheeling witness.
With respect, Justice Musaneke, it is so that this is sui generis proceedings. And it is so that this court said you must qualify your witness as you would do with Rule 39. But none of these witnesses have got a Rule 39 summary before the court. There are affidavits though, but there's no summaries to and if I want to qualify the witness in his evidence now, there's no reason why I cannot do that. He's not called by me, with respect.
Well, I've had any more submissions of the matter? I still have to make a ruling on that. I heard you.
Court, please.
Advocate Quinnaval?
I think my colleagues have made the argument. We have nothing to add. Thank you, Justice.
Yes.
Thank you, Justice Musaneke. I think the concession has been made on behalf of Section 27 that they are calling him as a direct witness to these proceedings. We can proceed along that line. But my understanding of the objection is that they are not objecting to this witness coming to testify. This witness can testify, but the capacity in which he must be allowed to testify is the one that is raised in question, whether he's going to be an independent witness that should be treated the same as the previous witness, as an expert witness or not. I think that's the issue. And the example I can put forth, Justice Musaneke, is the following. You have a doctor treating a patient, and there's a claim for medical negligence and so on. When you decide calling the witnesses, the first witness that must be called in dealing with the facts, whether there was negligence or not, is the doctor that treated that is the patient. Obviously, that doctor would have to straddle between, I think, the facts, what actually happened, and the expertise of that particular witness. This witness is unfortunately in that same position. He had been involved. He had witnessed what had occurred. You can't prevent him from coming here to testify about what he had witnessed. He can come testify about what he directly saw. And to an extent that he may offer an opinion, I think expert opinion on what had occurred. He had already provided us a report. In my view, he can be prevented from testifying on those things.
Yes. I'll go back to state now. I don't understand the objection to be to prevent him, is to be the kind of witness that he should be. Whether, in
Correct.
fact, he ought to, does he qualify as an expert and express independent opinion, or in fact is normal evidence, including the fact that he's an expert. He's a psychiatrist. That
Yes.
that is his field, and he knows the field. That includes the direct evidence. He can talk about that.
Correct, Justice Mseneke, he can testify about those things. He is here, he's an expert, he's qualified in that field. He can talk about that. I think even more, he has provided us with that is an expert report. Otherwise, if there was no expert report, then he will be prevented, obviously, from expressing any expert opinion. But to an extent that we have that expert report, then he is entitled to offer that there is an opinion on that.
Well, you have to make up your mind whether he qualifies as an expert witness or a witness in the normal course, isn't it?
Correct, Justice. And a concession has been made. He's been provided to this hearing as a direct witness, Justice.
And when you talk about his report, you mean the affidavit?
That's correct.
338.
Yes, that's correct.
Well, that is the source of the objection. That was an affidavit filed in litigation.
No. I'm sorry. There's 3548 in volume 11. I'm sorry. Page 3548.
Take me there.
That's an affidavit which he offers his expert opinion there in some passages as they appears. But in his view as a psychiatrist, what ought to have happened, he expresses an opinion on those. How they were treated and how they ought not to have been treated and so on. He offers his expert opinion on that.
Very well. Let's have you decided on what you want to do, counsel. Are you going to lead him as an expert witness, or lead him?
Justice, as I said, I think that the appropriate way to call this witness is to call the witness as a direct witness with expertise. So we can't ignore the fact that this witness
No, part of the
is
direct evidence is that he is a psychiatrist.
correct.
But he also knows a lot of the facts.
Indeed,
And he has also been part of litigation against the state.
correct.
So those things you cannot wish away.
No, to the contrary, we want to make much of the fact that he was involved and and why he was involved.
Sure. Okay. Very well. Shall we? The objection has been noted, and the witness will testify as an ordinary witness. You look surprised.
We have noted that, Justice.
Well, very well. Part of being an ordinary witness is being a psychiatrist and having been in the middle of it and having taken decisions which he believed were correct. I mean, all of that is part of the evidence, obviously. And you'll have the opportunity to cross-examine in the normal way. Counsel, proceed, please.
Justice, I need you to swear the witness in first.
Oh, yes, at the very bare minimum. Dr. Talatala, welcome. In which language do you want to testify?
In English.
In English. Will you put your full names on record?
Vuiso Talatala.
Vuiso Talatala. Doctor, do you swear that the evidence you're about to give will be the truth and nothing but the truth? And if so, please raise your right hand and say, so help me God.
So help me God.
Council.
Thank you, Justice. Good afternoon, Dr. Talatala.
Afternoon, Council.
I'm not sure, can you please locate file 11? And can you turn to page 3560 of volume 11?
Yes. I have it.
Is this your CV?
Yes, it is my CV, Council.
You are a specialist psychiatrist, as it emerges from your CV.
Yes, I am a specialist psychiatrist.
Thanks. Let's start at the beginning. When did you become aware of the project called the Gauteng Mental Health Marathon Project?
Can the doctor tell me what his qualifications are? And how long has he been a specialist psychiatrist, and where has he practiced?
I've got Bachelor of Medicine and Bachelor of Surgery from the University of Natal, which I qualified in 1997. And I've got the Fellowship of the College of Psychiatrists, which I qualified in 2003. And I've got a Master's in Medicine in Psychiatry from University of Natal, which I qualified in 2009. I've been a psychiatrist since, a registered psychiatrist since 2004. And I've been in private practice, full-time private practice, from 1st of March 2005. And I've done other roles.
Wonderful, thank you, doctor. Just in case there's some young people out there listening or watching, you would know that it could be done if there's forbearance in obtaining proper qualifications and skilling oneself in a specified field. Thanks, Councillor.
Thank you, Justice. The question was, when did you become aware of the Gauteng Mental Health Marathon Project?
I would not put a date by that name, but in terms of the rumors and the project, I think I became aware about it as early as beginning of 2015, February, March, when we heard that there was a rumor that the contract with Esidimeni was going to be terminated.
And what did you do when you heard the rumors?
Well, initially it was just to take a step back. We were in consultation with the Department of Health as partners.
When you say we were, who do
I
you
mean the
mean?
South African Society of Psychiatrists.
And what was your role in the South African Society of Psychiatrists?
I've been in the board of the South African Society of Psychiatrists for the past 7 years. But at the time of this project, I was the president of the Society of Psychiatrists. At the moment, I'm the past president. I'm still part of the board of the South African Society of Psychiatrists.
And just before we move on, I think it will assist us just to know what is the South African Society of Psychiatrists? Who are its members and how big is it?
Okay. The South African Society of Psychiatrists is the society that represents the interests of psychiatrists and psychiatry as a discipline and the interests of the community as it relates to mental health and psychiatry. We've got a fluctuating membership. We've got about between 600 and 700 members. We represent over 90% of psychiatrists in South Africa. Paid up members. Some are
700.
between 600 and 700 members. It fluctuates depending on when people are paid up.
90% of professionals
of psychiatrists in the field of psychiatry. Some are in the private sector. The others are in the public sector. So we are registered as a the society itself has been around for over 60 years and became registered as a company, I think, in about 2007. So we've got a company structure that runs the society.
Thank you. You were saying that you, so being representative of SASOP,
Yes.
had a meeting with the Mental Health Directorate. Is that the Mental Health Directorate of the Gauteng Provincial Department of Health?
Okay. What happened? What would happen in the past? Would have standing meeting, regular meetings with the Department of Health Gauteng through the Mental Health Directorate. So about 3 to 4 meetings per year. That will be representatives of the national SASOP as well as our provincial structure would meet the Mental Health Directorate on a regular basis, as I said, 3 to 4 times. And
why would you do that?
Would meet to discuss issues of, there's lots of challenges in terms of provision of mental health. So would meet to advise the Provincial Department of Health based on our expertise on how they should go about. One of the biggest projects is that with the National Department of Health, there was a National Mental Health Policy Framework that was published in 2013, which guided on, for instance, how patients will be discharged, on how mental health services will be established. This mental health policy framework has been done by the National Minister of Health, but it started at the provincial level where psychiatrists, psychologists, government had meetings where they discussed on how they would review, how they would work, improve mental health between 2013 and 2017. This culminated in
how they would work to improve mental health care going forward.
Going forward, yes. And then they published, and then there was a national meeting where all provinces were represented, including the South African Society of Psychiatrists and other societies, where then the document was published on National Mental Health Policy Framework and Strategic Plan 2013 to 2020. Now, the next step would be how to then translate that document into Gauteng, for instance, or to Eastern Cape or to any other province. So that would be one of the things we would meet for, because it does speak to deinstitutionalization and it has certain guidelines, not guidelines per se, but it advises on how things should be done. So we're meeting partly for that, but several other day-to-day issues in mental health. Whether we are dealing with, I wouldn't remember all the was in the agenda specifically, but whether we're dealing with the waiting lists in the forensic unit, which are current challenges, or any other challenge.
So in other words, it was a standing meeting. You were present at the meeting to discuss a range of issues.
The first one, I was not present, but I was represented. But the second one, which was around June, I was physically present.
And who, can you tell us about the meeting?
Well, in the first meeting we did, it was repeated to me that the issue of the rumor that Life Esidimeni contract was going to be terminated was raised, but it was not entertained in the meeting. And in the second meeting where I was there, I think around June, if I remember.
Of what year?
2015. Yeah, before the closure. In that meeting, which I was present, the issue was raised, but the department directorate felt that we're of the opinion that we can't discuss the closure of Life Esidimeni because they were still having contractual dispute with Life Esidimeni itself.
So at that meeting, you had no discussion?
So we raised it, but it was not discussed.
And what did you do next?
Well, we then wrote to the department, to the Department of Health. We wrote in June 2015 to the MEC, to the Directorate itself, Mental Health Directorate, and to the National Mental Health Directorate. Those are the people we copied. In fact, we wrote to the MEC, but we copied the National Mental Health Directorate, the Head of Health in Gauteng, it's in the document, several other people, including correctional services.
Can I refer you to page 3574 of file 11?
Yes.
Is this the letter that you're referring to?
Yeah, that is the letter I'm referring to.
And why did you write this letter?
We're concerned about the possible closure and the fact that this was going to be a big project in our view, and it was not being brought to the usual discussions that we're having with the Department of Health. And we did raise a few concerns that we had about what would happen to the mental health care users at Life Esidimeni, and what would happen to the services in general, just never mind the Life Esidimeni patients, but the impact it would have on the acute units that we have, and also on the forensic, on the patients awaiting forensic observations, as well as state patients in prison.
Dr. Talatala, I'm sorry, Counsel. I would like all the names of the people you wrote to, you copied in, to be put on record. I think it's going to be quite relevant, not long from now on. I'd like you to read, besides the MEC of Health in Gauteng, Ms. Qetani Dorothy Mahlangu, all of those names and the positions of people you copied the letter to.
It's thanks, Justice. It's Mr. S. Pagati, Director, Mental Health and Substance Abuse, National Department of Health. Dr. B. Selebano, Head, Gauteng Department of Health. Dr. N. Mazamisa, Chief Director, Hospital Services, Gauteng Department of Health. Ms. M. Lerutla, Chief Director, District Health Services, Gauteng Department of Health. Dr. M. Manamela, Director, Mental Health and Substance Abuse, Gauteng Department of Health. Ms. E. Dlamini, Head, Department of Justice and Constitutional Development, Gauteng. Mr. Z. Modise, Commissioner, Department of Correctional Services, Gauteng. Mr. E. Ledwaba, Coordinator of Health Services, Department of Correctional Services, Gauteng.
And was this letter, do you know that this letter was, reached the people who have been copied in?
We sent it via email, Justice, and it was some of the people confirmed that it was the emails were read, but we never got a response.
At the end of the letter, it appears to have been signed by several people. Would you explain that to me?
Okay. I'll start with the bottom one, which is myself. At the time, I was the president of the South African Society of Psychiatrists. The Professor Bernard Jansen van Rensburg was the president-elect at the time, and he is in full employment of the state. He's a psychiatrist in full employment of the state. I was in private practice at the time we signed the letter. Adjunct Professor Rita Thom was a chairperson of the SASOP Southern Gauteng subgroup. That is our provincial structure. So she was the chairperson at the time. Then Dr. Leslie Robinson is part of the board of SASOP, and she looks after the interest of the public sector psychiatrists. The society itself has got, as I said earlier, two arms: the private psychiatry and the state psychiatry. So she would chair the public sector part of psychiatrists.
Why was the letter signed by so many people?
Well, it could have easily been signed by the whole board, but we're trying to emphasize the importance of this letter and our fear of the consequences of what was going to happen. So I think it has that weight.
You were trying to give weight to the message,
yes,
by having all these high-ranking officials sign the letter,
yes,
co-signing the letter. And why was it sent to so many state functionaries in different departments that you had just read into the record?
I think one of the reasons is that, well, if the patients were discharged, all those departments were going to be affected. That's the first problem. But the second problem is that, which is my opinion, when you're dealing with the state, it could be denied that you actually communicated. So we had to send to as many people, especially those who were responsible. So we couldn't just send to the mental, at the time, to the mental director, because then later on, when we are dealing with issues of forensic psychiatry, for instance, then the correctional services will appear as if they are not aware of the challenges. And we also wanted to support of everyone in government.
So you're trying to rally support from the different parts of state by making them all aware in their respective and important positions.
Yes.
Shouldn't we go and eat, Council?
Justice, this would be an opportune time to adjourn. I'm still going to be dealing in detail with this letter, but we can do that when we return from the
Yes,
adjournment.
I'm sure you'd want to do that. Dr. Talatala, we're going to find some sustenance. We do back at 2:30. It is 1:30 to 2:30, and we hope to see you back then.
Thanks, Justice.
Thank you. We're adjourned.
Mr. Pett, do not forget,